All right, our next case is Rosen v. State.
May it please the court. My name is Chan Muller. I'm a lawyer from Winter Park, Florida. I represent the appellant Ronald Rosen. I would like to reserve 5 minutes on rebuttal.
Certainly.
In volume 15 of the supplemental record on appeal, which the court has, there are a series of photographs, 1 through 6, that were taken of Mr. Rosen's classroom during the time of the alleged offenses. And if you look closely at the record, the last 4 photographs have to do with a classroom by Mrs. Lowe, and number 10 and 11 are Mrs. Lowe's classroom, and 8 and 9 are other classes. The introduction by the trial judge over objection by the defense was totally prejudicial and inflamed the jury in this case. Our position is that the court should reverse on that basis alone.
Well, explain that to me, counsel, because frankly I found it a little confusing. What's so inflammatory about these photographs?
Your Honor, there's no question on the photographs that were taken of Mr. Rosen's room, that would be, and the defense did not object during the time of the trial, and that is totally relevant because the jury could decide whether he built an enclave with computers, whether he had filing cabinets and bookcases, as the state we submit improperly stated in the brief. What is prejudicial is the fact that there is no probative value, there's no relevance to the ultimate issue of whether Mr. Rosen committed the crime of lewd molestation or lewd assault based upon the introduction of other teachers' classrooms.
Well, what's prejudicial about it?
I'm just having a hard time with that point.
What's prejudicial is the fact that it's a non sequitur to take out separate classrooms and say just because Mrs. Lowe or just because some other teacher set their room up in X fashion, ergo, as the prosecutor argued in her final argument, Mr. Rosen had the lustful intent to commit the acts in question. And Judge Thompson, as you asked in the previous argument, I submit here this would be a clear case where the court should take a look at the final argument. If you look at page 1174 of the argument by Julia Lynch, she said that if his classroom had been set up the way that Mrs. Lowe's class was, see how open that is? There's no way, and you will get these pictures back in evidence. She goes on to talk about in Mrs. Edwards' classroom, the desk was right up front here. What relevance does that have to whether or not Mr. Rosen set his classroom up in a particular fashion? And the case law is clear, and we've set it forth in our brief.
Well, doesn't that at least go to the issue of whether or not there was the teachers had a right to set up classrooms any way they wanted, and that there were other ways of setting up classrooms?
Well, and the testimony was from the trial that Mr. Rosen's classroom had been set up the same way since 1996.
Sure, and the jury had that to consider.
But the point is, Your Honor, that when the judge is the gatekeeper here, in under 402, the only evidence that is relevant is admissible. It would be relevant to look at the way Mr. Rosen set his room up. It's irrelevant on how somebody else did it. Even if, which we don't concede, even if there's some marginal probative value, some shred of evidence that the state can hang on to, this is a clear indication under Section 403 of the Evidence Code why a trial judge has to be very careful if the possibility of prejudice outweighs any probative value. And if you look at the record here, this was a 5-day trial. The core issue in this case had to do with intent. Lewdness is not defined in
Isn't the case law that it's a jury question, and any information that will help the jury understand whether or not there was an intent is relevant to that issue?
If it's admissible. In the McCrae case that just came out, Judge Thompson reiterates the fact that a trial judge, in all respect, can't hide behind discretion or just the premise that any evidence that is relevant, because the rules of evidence provide that you cannot allow, as a trial court, any evidence in that would cause undue prejudice and confuse the jury.
Your argument, as I understand it, is that the photographs themselves are neutral. It's the way they're used in comparison to his classroom. That is, everybody else, or the ones introduced, the pictures introduced, show a class with the teachers up front, the students toward the back. In his classroom, the teachers in the back with the students up front with a barrier that would prevent people from seeing the students when they're with the teacher. Is that your argument?
No, Your Honor.
Okay.
I respectfully disagree with the court because the photos aren't neutral. If the court allows something in that's irrelevant, it by definition is not neutral. The case law is replete that any evidence against the defendant is going to be prejudicial.
Well, combining that with the testimony of the appellant's wife as to how it was set up, when it was set up, which was contradicted, isn't there a basis for having those other photographs in evidence?
No, Your Honor, not in this particular case, because of the fact that the whole core issue in this case had to do with the fact that the state was arguing that Mr. Rosen had multiple victims. He was a male. The young girls were in their 11 and 12 years old. And in fact, where the prejudice really spills over, and here we've got an experienced prosecutor, Julia Lynch, who's a sex crimes prosecutor. She's up there hammering the jury. You have to look at the final argument because that becomes a centerpiece of the case. And Judge, your own court here in the Mitchell case, which even the state cited, and I submit really supports our position, because in basically what the state is arguing is that if the defense was to prevail, then if my client didn't say a word when he, quote, fondles the alleged victims, any pervert could go fondle young girls, and if he doesn't say anything, he gets a free ride.
Mr.
That's what's good, Mr. Thompson, right?
Well, I was going to say something else with Mr. Mulligan. Isn't it, don't you have a problem because if the court can allow gruesome photographs in, autopsy photographs in, because the court feels that would assist the jury? If you look at these pictures, comparing them to cases that deal with gruesome photographs, and if the court can allow in gruesome photographs of very horrible crime scenes, why is it the court in this case could not use its discretion to find that these are admissible because they go to the question of intent?
Your Honor, that's a good question. The point is that in the gruesome photographs, which there's a whole body of case law, even though they're gruesome, if it goes to explain how the perpetrator committed the crime,
Or to assist the jury in reaching a conclusion.
but the photographs have to be relevant. For example, Judge, in the Gomico case, which we cite in our brief, the court reversed a trial judge because that was a suit against the manufacturer, and they showed a severed foot. Now, I mean, the court knows as a former trial judge there are plenty of photographs of severed body parts, but because of the company it kept in that particular trial, they would not allow that in. You can't, for example, the Williams case, which I cited, they showed a video of a raging defendant in a holding cell. The court reversed. What relevance did that have? If you go into the issue...
That's a little easier case, though, what you think?
Well, in the JOA argument, what I was going to say about the Mitchell case, you had a 30-year-old man who kissed an 11-year-old girl on the mouth. He inserted her hands between her shorts and her panties, and that came up here on a court granting a C4, and the state appealed it, and the court ruled that we can't say, as a matter of law, this is not lewd conduct. But you had actions. I defy the court, and the state can't do it. Every one of these young women testified that there was no prior statements by the defendant, nothing that they believed that he had sexual intent. In the Washington case, which was cited Washington cited Mitchell, we had a teacher who looked outside his room a couple times, invited this 15-year-old girl in, turned the lights out, And then he gave her what he called a full body embrace, and he kept on messing with her until the janitor came in. What we have here is a circumstance where...
But who decides what's lewd? Is it the court or the jury?
The court is the gatekeeper.
Well, when you say gatekeeper, are you talking about the evidence or the testimony of the young ladies? Because in this case, you have a number of young ladies who felt uncomfortable with the touching on the buttocks and the hug, that they felt were more like girlfriend, boyfriend. You had a number of young ladies in a series. You had notes to the principal where they were concerned about this behavior and asked the principal to investigate. So my question to you is, if it's a jury question and the jury hears this, are you now asking us to decide that the jury was wrong in determining that this was lewd behavior?
Your Honor, I'm asking the court to go back where the Florida Supreme Court and the appellate courts require a judge to be in a totally circumstantial case. This court, the trial judge, has to find that the state has proven the allegations and that it's totally inconsistent with any hypothesis of innocence. Just give me 30 seconds here because I'm into my rebuttal time.
I'm going to give you some extra
Yeah,
time.
we need extra time.
This is a difficult case.
Okay, let me give an example. Maybe this is a bad metaphor. Let's say I have two transparencies up here. I have one with the conduct that is alleged by Mr. Rosen listed out, that he squeezed somebody's buttocks. By the way, the state conveniently ignores the fact that in Charlie Edwards and the Manchester girl, where one of them said that he grew a long arm and the other one said he gave me a boyfriend hug, the jury found him not guilty. And alarmingly, the trial judge took that case, that particular alleged victim, and used that as a predicate to do an evaluation on whether or not the court would grant a JOA with regard to some of the other alleged victims. And what the court did, the court can't abandon an analytical analysis of each count. The trial judge in this particular case, and I say this in all respect, stated, well, I'm going to look at the fact that there were a number of complaining witnesses here, and the court then abandoned its duty to look at each case individually on the JOA.
But isn't the fact that there were so many, there's a pattern here, how could the jury, how could the judge not take that pattern into consideration?
The judge has to look at the facts, Your Honor, with regard to each particular case. And here's why this is so critical. And the Bowles case is an exact reason why this is so dangerous. Bowles was a Florida Supreme Court case decided in 1946. Mr. Bowles had a shoe shop. A little 11-year-old girl would come in to bring her shoes, and the state's evidence was that he reached across the counter, put his arms around the little girl, and called her his little sweetie, and told her, watch out for the machines. The state attorney got 4 other young women to talk about the same thing, just like the state did in this case. The Florida Supreme Court reversed, because the Florida Supreme Court said in circumstantial evidence cases, there's a higher standard on the part of a trial judge. The only way that this could go to a jury legitimately would be if there is a disparity between the theory of the defense and the state's theory of guilt. The theory of the defense in this case was simple. Mr. Rosen, if he touched these young women, it was a de minimis touch. It was without intent. The state's theory was that this was a closet pervert who would take advantage of these young girls right in his classroom. And interestingly, a couple of the alleged victims said that this happened outside the classroom. But what they did, they shoehorned the judge, who didn't even question the prosecutor, well, what relevance is this? And they got these photos in, and then the judge, the prosecutor, makes it a centerpiece of her final argument. So going back to what the court is required to do, in order to prevent conduct which arguably would be atypical or idiosyncratic, I mean, here's an example. In using this deal I tried to set up where you have the transparencies, if you took his conduct and wanted to find him guilty of a mythical crime of being an overzealous, touchy-feely teacher, as opposed to a pervert, the same facts would be there. And the point is, if you have a juxtaposition of those same facts, then the court has the duty on a JOA to analyze this on an analytical case-by-case basis.
20 minutes are up. I'll give you 5 minutes for rebuttal. If you
Thank you.
sit down now.
Thank you.
Sure.
So sometime during rebuttal, we need to talk about the Apprendi issue.
Right. We want to hear about Apprendi.
Okay, all right. I'll tell you what I'll do. I'll lead off and use 4 minutes on rebuttal and just talk about it, okay?
Right. Whatever you want to do.
Thank you.
You want me to sit down?
Yes.
Thanks. Judge, I'll sit down when you tell me.
Oh, I told you to sit down before.
You did too.
Thanks.
Good morning, Your Honors, Counsel. I am Tim Wilson here on behalf of the state of Florida. Just quickly, as to the photographs, they were relevant for several purposes, as the trial court said, and they're not prejudicial. They're actually pretty innocuous.
They're innocuous. Why were they sought to be introduced?
Because they were relevant.
Well,
But they
they were
weren't
relevant
prejudicial.
if you're going to say teachers have a design problem and you're doing a redesign of a classroom, but as to why they're relevant to show lewdness or an intent to commit lewd acts, how are they relevant?
Well, they were relevant to show opportunity, that he created an opportunity to do this.
But wouldn't that be shown by his class photograph to show how it's like a cave or an
Show
enclave?
it that way and by comparison to other classrooms, which is
Well-
what the other classrooms are for.
Wasn't that a matter of taste? If you go into middle school, each teacher designs the, I call it a blackboard, but that's probably wrong, but each design the wall designs in their classroom. Some teachers have a circular pattern. Some teachers have their desk in the back with the kids up front. Some teachers have what I would call traditional, their desk up front and the kids facing them. But isn't that a matter of taste?
Yes.
And what does that have to do with intent to commit a crime?
It's not necessarily directly related to the intent. I mean, that's focusing on intent only to commit the crime is not the only reason that these were relevant. There was testimony as to how this came about.
You know, counsel, I've been in classrooms designed this way. I have been in classrooms, visiting in classrooms that have been set up the way this one was.
Yes.
So why didn't you bring in some of those?
I don't know why the state chose to show what they showed, except that those other classrooms were right next door to this one. If you'll recall, there was also the testimony of the young lady whose desk was right next to the teacher, and I forget the teacher's name, who said something out loud, and the other young lady hears and tells her mother, and the mother calls the school, and that is one of the ways that this behavior came to light. Well, the photograph of how that classroom was arranged is relevant to that testimony. So there's more than one way this was relevant.
Well, even if they are relevant to show the differences, and there may be an insidious reason for setting it up, what concerns me is the emphasis in closing of the prosecutor on these innocuous photographs. Do you want to comment on that?
That was proper argument. There was nothing improper about that argument. And the fact that
That's the only reason that brought him in, wasn't it?
And the fact that the prosecutor used the photographs to compare the different rooms to suggest that his was set up so that he could do what he did is proper use of the evidence and proper argument on the evidence, and shows why the evidence was properly admitted. It is not so overly prejudicial that the jury was somehow to be confused or that they somehow made their decisions based on some kind of emotional response. Or, I mean, these are just classrooms. And the fact that they're set up differently is a point that needed to be made and could be argued to support various issues in the case. But that they were so prejudicial that it constitutes error, they just don't rise to that level.
How can we tell? How can we tell whether they rise to that?
Just by looking at them.
So it's kind of a gut thing? Is that?
No, trying to think of how to say that. Because they're not. I mean, they're,
Oh, well.
I'm sure Ms. Cochran said it much better in her brief, and I apologize for not saying it right here. But I want to move on quickly because I also want to get to the Apprendi issue.
Yes.
Because I think that that's really the issue in the case. As to the JOA argument, I think there's two things. One, look at the verdicts. This jury had absolutely no problem.
Well, that's fine. The question is, the JOA comes before the verdict. So the question is, did the judge do the examination and clarification as to why some would go forward and some would not?
Yes. The judge granted the judgment of acquittal as to one of the counts.
So you're saying
The judge
if...
obviously was looking at each of the counts because he granted JOA as to one count. So that is an indication that the judge did his job properly by looking at each of the counts.
Is your argument the judge does not need to articulate with particularity the reasons why he did what he did?
No, he does not need to articulate that with the judge, and they very rarely ever do.
So is your argument there is no case that says a judge must have a checklist that he must pronounce as to each victim or to each count, but he can generally say the state has met its burden here and has not met its burden here, but unless asked, does not need to articulate specific reasons? Is that your argument?
Yes, essentially, because that's what he did. I mean, he clearly looked at the totality of the circumstances, and one of the things that came out in this case was this evidence was admitted for all purposes, not only as to each young lady, but as to its effect as to all the young ladies and the pattern and motive and all the, in other words, each count was related to every other count. And
Well, what do you say to his argument that the judge used some counts that the jury had acquitted, or he, later acquitted?
Which I guess is that's the proof of in the pudding, if you will. I mean, that's the proof of why it was appropriate to allow it to go to the jury, is because that's the jury's job.
That's the jury's
to
job.
assess all the evidence, to hear the defense case, to weigh and balance and acquit on some charges and find lessers on some charges and finding guilty as charged on the others, which is what I say the proof of the fact that the JOA was properly denied is the verdicts. The jury clearly did what they were supposed to do by assessing each individual count as to each individual victim, and found only those crimes that they believed had been proven beyond a reasonable doubt. Like I say, some were acquitted, some were lessers, and some were found as charged, and that's about as clear as you can get to show the jury did what they were supposed to do. With regard to the Apprendi issue, there are several things that are important to keep in mind. One, it has absolutely nothing to do with the convictions. Okay?
Is it simply a sentencing error that you're concerned with? Is it simply the sentencing that you're concerned with?
It is only a sentencing error.
Well, that's a big error. Look at the number of years, and look at the sexual predator designation.
A first-degree felony for one count,
Big deal.
or a first-degree felony, or that one count being second-degree felony. Okay, this is solely.
All be third degree.
Hmm?
They would all be third
No.
degree. No?
No, because this court has already said that his age is proven. This court has already said that that is not an Apprendi error. He was clearly over the age of 18. The jury had the opportunity to hear testimony as to his birth date. The jury had the opportunity to sit and look at him throughout the entire trial.
Well, he taught in the public schools for 18 years, yeah? He taught in the public schools.
He taught public schools for 18 years. He'd been married for 31 years. There's no way in the world that he is under 18 years of age, and this court has already said in the, I think it's pronounced Peretti, that error is not reversible. That it is okay to say he's clearly over the age of 18.
That case says it wasn't an issue at the trial.
And it wasn't an issue at the trial. But there are other cases also that the state cited in the brief that his age is not a basis for an Apprendi error.
So let's get to the age of the victim in the first-degree felony.
The only thing left is the age of the victim. The
Now we're
Peretti
talking about between 11 and 12.
the one victim, the one who was 11. The record is absolutely clear in this case as to what the ages of the victims were.
Is that because they testified to their age?
Every single one of them testified to their age. And every single one of them testified to how old they were now and how many years it had been since they were in 6th grade. And the math is easy, and we know when these events occurred. We know a beginning date, beginning of school, and the last possible date. Every single young lady testified to her birthday. There's no question whatsoever how old they were. The only question is whether or not it was error for the jury to not say, oh, by the way, we find this one was 11 and this one was 12.
Was there a dispute about the verdict forms as to the elements that needed to be on the verdict forms?
There was no dispute to the verdict
Was
forms.
there objections to the forms that were presented to the jury by the...
No. There were no objections. There were no disputes.
What did the information charge?
The information charged in the one case of the 11-year-old, the information charged that he, with lewd and lascivious intent, touched her on her buttocks, and that she was age 11. The information charged that she was age 11.
Yeah, the information's charged, the instructions did not.
The instructions only said under the age of 16 because that's the elements of the crime. Again, this is not a problem with the conviction.
Does the jury verdict come back guilty as charged?
The jury verdict says guilty of the charge. So, no, I don't have the benefit of the as charged, which I would love to have, but no, it doesn't say that. It says guilty of the charge. But, again, the information clearly charges that she was 11. The fact that she was 11 was never once disputed. And that's why the state believes that the Perret case is probably the Freddie case is the one most on point in this, is that in order to have an Apprendi issue, you need to have a fact that was in dispute that the jury did not find. Because the jury's job is to find all these facts for sentencing purposes also now, not just for conviction purposes, but we now want the jury to find these facts for sentencing purposes. But in order to have that be a problem, you need those facts first to be disputed.
Has the Supreme Court said that so far?
No. No.
Either one?
No. Not that I am aware of. No. But, again, Freddie does seem to be the most common sense approach, which is in order to have this be a problem, you need to have...
Au contraire, I don't think it makes much sense at all. Anyway, that's all right.
As an alternative, I would suggest this. If indeed this is an error, that the jury had to find this fact in order for this to be a first-degree felony, then the proper remedy is to remand it for a jury to find this fact.
Or reduce the sentence down to a felony of the second degree?
No. Reverse and remand it for a hearing to establish the fact.
How many times does the state get to prove its case?
This isn't about the state's case. This is a sentencing issue.
Well,
This isn't a conviction issue. It's
Can't reconvene this jury.
I would agree with you.
No, a sentencing hearing's not going to do it. We can't get back to that jury.
You don't need to get back to that jury. You need to get to a jury. This is a sentencing issue.
Multiple juries
In
aren't
capital
normal here.
cases, this happens all the time. It is remanded for sentencing before a new jury.
A
And
new
there's
jury.
no problem with that, because the issue is that Apprendi says we want a jury to find this fact. It doesn't have to be this same jury. This isn't a double jeopardy issue. It's a sentencing issue. It is not a conviction issue. There is no bar to having a new jury impaneled for the sole purpose of
Do
determining...
you have some cases that say that?
No, I couldn't find any. I couldn't find any, except for by analogy to the death penalty cases, which there are many, many death penalty cases where it has been remanded for sentencing and the...
Hasn't the Supreme Court resolved the issue, and that is that since there was no objection, the form was not objected to, there is testimony in the record, and the factors that are used to aggravate the sentence are cleared, that there is no need then for a reversal, at least for new sentencing, or to reduce to a felony second-degree maximum sentence.
I don't know that any court has spoken directly on this point as to, again, the Freddie case spoke about the age of the defendant, but I don't believe that this particular set of circumstances has appeared before any court. I did not see that as I was reviewing the case. Again, I came late.
What then is a recommended cure, to have jury instructions as you would with a firearm case or with a mask or with a quantity of drugs, have that specified on the jury verdict form, the age of the defendant, the age of the victim at the time of the crime, etc.?
In the best of all possible worlds, the right way to do this would be to have every fact that is related to both the conviction and to a possible sentence listed on the verdict form.
Would it only have to be a sentence that's above the statutory maximum for that particular charge?
It would only have to be a sentence that's above the statutory maximum, or a fact that is necessary to determine what statute applies.
An
And
aggravator.
in this case, that's the problem.
An aggravator that the court would use to increase the punishment.
Yes.
Well, isn't that what Apprendi starts with? You had a race hate crime, and the court said, well, it wasn't clear, so that it made then to be reduced back to the maximum allowed by statute.
Yes. That's that, because it went beyond the race hate, the hate crime aspect of it, bumped it beyond the statutory maximum. The problem in this case, of course, is that the statutory maximum changes depending upon this sentencing fact.
So isn't it then fair to the defendant to sentence to the maximum allowed by the lowest possible charge under those circumstances?
I'm sorry, I didn't hear the first part.
A felon in the second degree without aggravators?
Well, see, it's not an aggravator. It's a change in the statute. A different.
It increases the penalty because of a fact that was found or supposed to have been found by the jury.
Yes, it changes the penalty.
It changes the maximum sentence,
It
which is
changes
right in the
the
middle of the Apprendi problem.
It changes,
our
and
problem.
that's why it becomes an Apprendi problem, is because, yes, it changes the maximum sentence. The real problem, of course, is that nobody ever asked the jury to make this finding.
Well, that's the prosecutor's problem.
And that is the prosecutor's
Put that on the
job.
defendant.
Hmm?
You can't ask the defendant to
No, no.
raise this.
no.
Oh.
That's the
There
prosecutor.
was some suggestion in your brief that that was the defense's problem, that they should have. So,
Like I say, I didn't write the particular brief.
Oh,
I do
okay.
think it is well written.
But
It is true that nobody objected to any of these forms. Nobody objected. I mean,
it's not like they sandbag the state. It's the state's obligation, is it not?
It's the state's obligation to provide the verdict forms that are acceptable to both parties and to the court, yes.
And that are legally sufficient for the
And
sentence to be
legally
imposed.
And as to the crime, they were legally sufficient.
which crime?
The crime that was charged, lewd
All right.
lascivious
Okay.
molestation under age 16, that is what the verdict forms and the instructions, that's what it charged. Again, that's the crime. The crime was clearly proven. We're not talking about convictions. Again, we're talking about sentencing.
Yes, we know.
So, for those reasons, we feel that definitely all the convictions and all of the sentences ought to be affirmed. And again, if you feel that that one sentence has to be reversed,
We understand.
that you should remand it and allow them to fix the problem, because it's not a double jeopardy problem.
All right. Thank you very much. I'm going to give you 3 more minutes.
In Blakely, we pointed out at page 44 of our brief that the maximum sentence is based solely on the facts reflected in the jury verdict. The jury verdict here does not unambiguously tell us what they considered.
What is the cure, though? The state has argued that the cure is a new sentence, a la sentencing when the Supreme Court says it was in error, go back, sentence again, or return for a maximum sentence based on the statute for a felony of the second degree.
Your Honor, the cure would be a reversal and remand and discharge.
Why?
Well, in this particular case, we have double jeopardy with regard to the
Well, he was found guilty of the information that charged. The question is, I call it an aggravator, you may call it an enhancement, but the issue is the penalty to be imposed based upon the ages of the children
I
involved.
misspoke. It should be an F3. That would be my position.
Okay.
I was wrong. It should be an F3. Judge Monaco, when you wrote the Perrette decision, I think you noted to the prosecutor here, in that particular case, it was a non-issue because it was a Burnham or Turnham issue with a defense attorney. But importantly in that case, too, there was no issue about the alleged victim being under 12. In this particular case, it's not incumbent upon the defense to prove the state's case. At page 767 of the record, the only thing that went to the jury was the jury instruction under 16. And so even if we concede, which I don't, that common sense in the Perrette analysis and the factors that I acknowledge are in the record about the length of marriage and that type of thing, still the cases are legion, and we've cited them in our brief. For example, enhancement under 1020 life, mandatory 3-year minimum mandatory where there have to be specific findings. And in this particular case, even if we agreed that common sense would tell us that Mr. Rosen, it was proven he was over 18, they got a big gap here with regard to Amy Harmon, and that's why it needs to go back as F3.
So you concede that there's proof in the record that because of his 30-year marriage, his years teaching, his years in the community since 1959 are not debatable?
I don't concede that that rises to the level where the state doesn't have to have a specific instruction and finding by the jury at all. And what I'm trying to point out, and we did in our brief, is that it's incumbent on the state, even though the trial lawyer for the defense didn't make an objection, it's not incumbent upon the defense to prove it. There's a case, the Pate case, which this court rendered in December after the October verdict or finding in the Perrette case, points up our argument. That particular case, it was a per curiam decision, and the court found that the written judgment should reflect a second-degree misdemeanor rather than a first-degree because there was no proof and no instruction on the amount of money that was allegedly taken. And that case was decided, the same principle I'm arguing with regard to these other cases.
I guess I'd like to hear you argue about the absence of a finding with respect to the victim in this case, the 11/12-year-old.
Absolutely, Your Honor. Just because the state charged it in the information, we don't know what the jury verdict was here. You know, in the standard instructions, the trial judge says that you're to follow the instructions from the court. The court gives those instructions. Juries look to those instructions very closely. As the prosecutor candidly acknowledged, the verdict didn't say as charged in the indictment. It says as charged. As charged in the jury instructions, we don't know. And we're talking...
The instructions say find under 16?
The instruction, as I understand it, talked about 16 or younger.
Yeah. But it didn't specifically make the instruction didn't deal directly with under 12. It dealt only with under 16.
And this was a critical situation because of the age of the alleged victim. So the proper, when you apply Blakely and you apply all the legions of other cases out of this district and other districts that require the proof by the state without a burden on the defense to prove up these mandatories, it is a big deal, as Judge Sharp says.
All right, counsel, you can start your time.
Thank you.
Thank you.
Very interesting. Very disturbing.
Very good. Very interesting. Very good.
Well argued.